That's because they're suing AEG Live for a claim called negligent hiring, retention, or supervision of Dr. Conrad Murray. They say AEG Live hired Dr. Murray and that we were negligent in doing so. So you have to find two things. Did we hire him? And if we hired him, were we negligent in doing so? The negligent hiring claim protects people from bad hires. It does this by holding an employer liable when someone the employer hires hurts or kills someone else. And Mr. Panish said yesterday the law makes sense. It's fair. Justice is for everyone. And I absolutely agree with that. Justice is for everyone. And it is fair in this case. But what's not fair or just is to find AEG Live at fault for what happened to Mr. Jackson here. Because the law of negligent hiring only holds an employer liable, only at fault, if he knew or should have known that the person he hired might harm someone, but still hired or kept them on anyway. Like giving a person with a history of violence a job where he had to use a weapon. If you knew that he had a history of violence and you gave him a weapon, that would be a negligent hiring. Or keeping a driver after multiple arrests for reckless driving. You knew he had multiple or she had multiple arrests for reckless driving, and you kept him on anyway. That would be a negligent retention. And this only makes sense. It wouldn't be fair to hold an employer liable if they had no reason to know that, if they had no reason to believe that the person they hired was dangerous. That wouldn't be justice. You have to be on notice. In other words, you have to be on notice that there would likely be a problem. And that's important here, because as the court told you on Monday, I know it seems like a lifetime ago, but just 2 days ago, you can only find AEG Live at fault here if it knew or should have known that Dr. Murray was dangerous, but they hired him anyway. Or AEG Live hired Dr. Murray, then found out that what he was doing and didn't get rid of him. That's what the actual law is. So this case is about what AEG Live knew about Dr. Murray. Look at the questions. It's about Dr. Murray. Not what it knew about Mr. Jackson. And that's the diversion they've tried to take. Because you can't answer yes to these if it focuses on Dr. Conrad Murray. Look at the verdict form. You'll see that. And trust me, I'm going to go through it. And as the judge told you, plaintiffs have the burden of proof on this claim, not AEG Live. As you go through those, they have the burden. They have the burden of proving each and every element of their claim. And those elements are laid out on that same verdict form that you have to fill out. And plaintiffs must prove 5 different things. If they haven't proven even one of them, they haven't proved their case. And that's their burden. And we're going to talk about each just real quickly right now. Ready, Pam? Okay, first, have plaintiffs proved to you that AEG Live hired Dr. Conrad Murray? I think that question's easy, and we'll go through it. Because if anyone hired Dr. Conrad Murray, it was Mr. Jackson, not AEG Live. Second, if you nonetheless find that somehow AEG Live hired, you go on to the next, and that says, have plaintiffs proved that Dr. Murray was unfit or incompetent? And by the way, that's where they stopped yesterday. They only asked you if he was fit or incompetent. But that's not the question. The question is, was he fit or incompetent for the job for which he was hired? And that's the key. Dr. Murray was fit and competent to take care of the general medical needs of Michael Jackson, and that's what he was hired for. He had been doing so for the Jacksons and his other patients for years, without incident. The answer there has to be no. Third, have plaintiffs proved that AEG Live knew or should have known that Dr. Murray was unfit or incompetent, and that this put others, including Mr. Jackson, at risk of harm? In other words, did AEG Live know, or should they have known, what Dr. Murray was actually doing? Again, the answer and the evidence shows you that that has to be no. Fourth, if you get there, have plaintiffs proved that AEG Live's negligence, because what you're looking up before is to try to prove were they negligent, goes on to say, if they were negligent in the hiring, supervising, or retaining of Dr. Murray, was that a substantial factor, that supposed negligence, in causing Mr. Jackson's death? In other words, you can hire someone, it could be negligent, But if it's not the factor, if it's not the substantial factor, and again, they said there could be more than one substantial factor. But if that's not a substantial factor, well, in that case, you're going to have to say no. And the sad truth here is Mr. Jackson's death was caused by his choices. And it would have happened, no matter what, with or without AEG Live. How do we know that? AEG Live didn't hire him. They didn't advance any monies, and it happened anyway. Again, I think the answer there is no. Fifth, if they've proven all of those things, well, then they got to prove damages. And damages isn't something where you sit there and go, oh, whatever you guys think. Okay? It isn't as easy as that. You got to have some proof. Okay? You got to have something. And their dollar amount is $1.5 billion. They kind of rushed through that yesterday. I don't know if you noticed. Maybe they're a little embarrassed to throw it up on the screen, but it was there. $1.5 billion. I'm sorry. That's an absurd number. Absurd. And they haven't even remotely proved it. Not in any way. We'll go through it, but you remember that all that testimony from their supposed damages person. But the years and years of future recordings and sorry, not just recordings, but on tours that he was going to do. Because think about that. Their claim is he was so sick, and it was so obvious to everyone that AEG Live should have known that. Again, shifting the focus to him, because they can't focus on what they knew or didn't know about Dr. Conrad Murray. He's so sick that everyone should have known it. And then they turn around and say, but he was going to go on and make more money than anyone had ever done in history with 4 more world tours? It doesn't make sense, like the rest of their claims. Again, can't guess on that one. You've got to have some basis. You can't speculate. That's what the law says. So I'm going to quickly talk about something briefly, and then we'll go through them. And I want to talk about it because it's important. You've heard lots of testimony in this case about things people knew, about people who knew Mr. Jackson and what they did or what they didn't do, including AEG Live. Karen Fay, I'm not going to go through all of them, I promise, but Karen Fay, clearly she loved him, had for a long time. Yet she didn't confront Mr. Jackson with her concerns about his drug use. She didn't even ask him what was wrong on the 19th. She thought it would be wrong to do so. Now, if I recall, she thought they were best friends, but she didn't do anything. She said nothing to him. Elif Sankey, she says that she thought she should have called 911. She wanted to, but she didn't do it. Dr. Alan Metzger, remember, he talked about advising Mr. Jackson just before his death that he should go get some sleep care. Even though he did that, and even though he was concerned that Mr. Jackson had a profound sleep disorder, he didn't follow up. One of his best friends, a person of 30 years. You heard Dr. Sherilyn Lee. She failed to talk Mr. Jackson out of using propofol for sleep, though she tried. But she, too, never followed up. I can keep going. Travis Payne. He couldn't convince Mr. Jackson to do physical therapy. Randy Phillips. He didn't force him to see a psychiatrist. I can go through and through and through with everyone, because whenever a tragedy happens, it's easy to play that game. You can torture yourself. I'm sure his family has tortured themselves, and they shouldn't. You sit there and you say to yourself, if only I had done something. If only I had seen the signs that are now so clear with 20/20 hindsight. Or you can torture others. You can blame them. Tell them that if only they had done something, if only they had seen the signs that you can now see with 20/20 hindsight. That is a natural thing to do, but as adults, it's not what we should do. Because as the judge has instructed you, these kinds of should have, could have, would have, they aren't part of the decision you're here to make today. The law doesn't require you to save someone, even if your conscience, your morality, your love, your guilt, whatever it is, even if that tells you you should. That's not the law. There's not a duty to save. And who would ever, anyone who, and again, I talked about the idea before, anybody who's ever loved an addict, known an addict, cared for an addict, knows what that's like. You can't save someone. They have to save themselves. And more important for what you're doing here today, the law doesn't say you have to. Because if it were any different, if that weren't the case, everyone would be legally responsible for everybody else's decisions. And that's not how life works. And it's certainly not how the law works. All right, so we're going to go through the 5 things the plaintiffs have to prove. And we're going to go through them because I believe they haven't proved them. And unlike yesterday, the way we're going to do it is we're actually going to go through and I'm going to give you all kinds of facts that you've seen so that you can put it in a context to understand what you're going to decide. So the first one on your verdict form is hiring. The first question obviously had to be hiring. Who hired Dr. Murray? Because someone can only be liable for negligent hiring, retention, or supervision if you hire that person in the first place. You can't negligently hire someone unless you hire. You can't negligently retain unless you hire. You can't negligently supervise unless you hire. So the first question is, who hired? And you're going to be asked on that verdict form exactly what it says here. Did AEG Live hire Dr. Conrad Murray? It's the opening question, has to be. Now, remember, it's plaintiff's burden to prove that AEG Live hired Dr. Murray. And I believe that answer is no. AEG Live did not hire Dr. Murray, and I believe it for 2 reasons. And I'm going to go through both. The first is that the evidence is very clear that Michael Jackson was the one who hired Dr. Murray. And we'll talk about that. But the second reason, which we'll talk about in a moment, is that things never even got that far. There was never a contract. Plaintiffs want you to believe there was a done deal somehow between AEG Live and Dr. Murray sometime before June 25th, 2009. And even they can't really say when. They throw up a bunch of numbers. It was then, or maybe then, or maybe then. That's because there was never a done deal. And as the judges instructed you on Monday, plaintiffs have to prove that AEG Live and Dr. Murray agreed to be bound without a written agreement. They have to, for all their theories, they have to have agreed to be bound. And they have to agree to be bound without a written agreement, because we know there isn't one. And therefore, for either of those 2 reasons, I think your answer will be no. Now, let's talk about the first one. That it was Michael Jackson and Michael Jackson alone who hired Dr. Murray. Now, as the judge told you on Monday, there are 4 options here. And that makes sense. There could only be 4 options here. Either Michael Jackson hired him, AEG Live hired him, they both hired him, or neither one hired him. And I believe all of the evidence you've seen, evidence, not what people have argued. Because remember, what I say, what the lawyers say, that's not evidence. The questions aren't evidence. That's the evidence. And I think all the evidence shows that the only person who hired Dr. Conrad Murray was Michael Jackson, not AEG Live. Now, how do we know this? Well, Mr. Jackson selected Dr. Murray. We know that. There's no dispute about it. We know from Dr. Murray's records that he had been treating Mr. Jackson and his children since 2006. Now, I want to say a little something about those records. Don't forget, we didn't get everybody's records, and even when we got someone's records, we could only get part of them. So we're basing this on all the records we could get. There are unquestionably many more medical records out there. We didn't get them, though we tried. But from what we got, we know that at least since 2006, he was treating Mr. Jackson and his children. I don't think there's any dispute on that. You also heard the testimony of Jeffrey Adams, Mr. Jackson's former bodyguard. Remember, he's the one who introduced Dr. Murray to Mr. Jackson. Mr. Adams went to Dr. Murray's office in Las Vegas, as did his father. In fact, Mr. Adams' father was Dr. Murray's patient as well, just like Mr. Jackson. Mr. Panish tried to insinuate that Dr. Murray didn't have real practices. Do you remember that? He said it. No witness said it. Dr. Murray was a real doctor. All the evidence shows that, and he had real patients. Do you remember Stephen Gordon, Dr. Stephen Gordon from Las Vegas? Dr. Murray introduced himself to Dr. Gordon as Mr. Jackson's personal physician in 2007. Remember Dr. Slavitt? That was the doctor who gave the physical in February 2009 for the insurance. He testified that Mr. Jackson told him that Dr. Murray was his personal physician. It's Mr. Jackson saying that. That was in February. before AEG Live had ever met or heard of Dr. Conrad Murray. He didn't give some other name. He was asked who his physician was. He didn't say Dr. Metzger. He didn't say Arne Klein. He didn't say any of the many other doctors you heard. He said Dr. Conrad Murray. Dr. Murray was Mr. Jackson's long-term doctor. They can play that off as not true, but it's true. And the evidence shows it. That is what he told everyone. And he told them this long before AEG Live had ever heard of him. And Mr. Jackson was the one who brought Dr. Murray to Los Angeles. You've seen the evidence. Dr. Murray was in Los Angeles treating Mr. Jackson long before AEG Live had ever heard of him. He treated the Jackson children for colds in January 2009. That's in the medical records. He was seen at the house multiple times a week from at least the very beginning of April. We know at least that long. You've heard that from Kai Chase, remember the chef? Who testified that when she started working in Carrollwood, he was there. That's April. You also heard from Travis Payne, the choreographer, the one who went on the tour, and Kenny Ortega, the director. They told you how Mr. Jackson introduced Dr. Murray to them. Mr. Jackson introduced Dr. Murray to them in his house as, quote, my doctor. I'd like to introduce you to my doctor. And that's what they did when they met him. And that's the spring of 2009. You've also heard the testimony of Paul Gongalware and Randy Phillips that Mr. Jackson insisted that Dr. Murray come on tour and would not take no for an answer when they suggested anything else. Get someone in London. It'll be cheaper for you. Get someone in London. There are great hospitals. No, I'm taking my doctor. Dr. Murray had been Michael Jackson's doctor. He was Michael Jackson's doctor, and he was going to continue as Michael Jackson's doctor. And it was not for AEG Live to interfere with that long-time doctor-patient relationship. That's what they're asking you to do, interfere with that relationship. Dr. Conrad Murray was Michael Jackson's choice. Okay, so we know Mr. Jackson was the one who selected Dr. Murray. I don't think there's any debate about that. Now, what about payment? Well, Michael Jackson did that too. In fact, Michael Jackson had been paying Dr. Murray for 3 years. You saw that testimony, bless you. The whole time Dr. Murray was treating him. And Mr. Jackson continued to pay Dr. Murray in Los Angeles. You saw that testimony. Remember, he had his children, Prince and Paris, give Dr. Murray stacks of $100 bills. You remember that? We sat there and I go, how thick? This thick, that thick, this thick? He said it was this thick with rubber bands, $100 bills. And Mr. Jackson paid Dr. Murray through the day that he died at least 10 times in Los Angeles. That was the testimony. That's Mr. Jackson paying, not AEG Live. And did AEG Live ever pay Dr. Murray? No, never. The evidence is absolutely clear on that. They never paid him because they never hired him to go on tour. Mr. Panish said yesterday that AEG Live was, quote, giving the money to Dr. Murray, end quote. That is not true. AEG Live never gave any money to Dr. Murray, ever. That's the evidence. Now, that said, and you should listen to me on this one, even if, and this is a little wrinkle, even if there had been a contract, this is the first part, remember the second part I'm going to say there's no contract, even if some contract between AEG Live and Dr. Murray had been completed, let's just say it had, no, it wasn't, but let's say there was some contract, I don't know what it would be, okay, conduct, oral, some of the many theories that they've thrown, okay, say that happened, it still would have been Mr. Jackson that was paying Dr. Murray, remember? He was going to be engaged at Mr. Jackson's request and at his expense. This is one of the draft contracts that went back and forth between Dr. Murray and AEG Live's outside lawyer, Kathy Jory. Now, this is Exhibit 343. I'm going to say it again, 343. It's one of the drafts. And as you remember, whenever we could, we would show it with somebody on cross because they weren't showing it. And each of these drafts, every one of them, had a signature block from Michael Jackson, like the one here on page 6 of Exhibit 343. And as you remember, each one said, and I'm going to quote it, the undersigned, that's Michael Jackson, hereby confirms that he, no, I have it misspelled here, I know I do, yes, he has requested, producer, to engage Dr. Murray, he requested it, on the terms set forth herein, on behalf of, and at the expense of, the undersigned. Who's the undersigned? Michael Jackson. So if there had been a completed agreement, if there was any agreement, it would have been on behalf of Michael Jackson. It would have been at the expense of Michael Jackson. Dr. Murray's payment would have come out of Mr. Jackson's money, his portion. All AEG Live was ever going to do was loan it to Mr. Jackson. They'd loan that money, and they were only going to do that if Dr. Murray ended up coming on the tour. Just like they did for his house, just like they did for his art. Remember when I bought art and they were paying for it? That's because he was $500 million in debt. That's why he went to AEG Live. They were going to advance in the monies because no one else would anymore, remember? They shut off the credit cards. Remember that? They couldn't get the advance? Or what was it? No, the increase? Mr. Jackson was also going to be taking responsibility for Dr. Murray. Now, you saw the contract between Michael Jackson and AEG Live for the tour. Not these drafts, but the one between Michael Jackson and AEG Live. And that's Exhibit 66. That's the actual agreement they had. And this is a contract for the shows that were going to be in London. Well, that contract gave Mr. Jackson the right to bring a tour party, it's called a tour party, to London with him. That's what he was allowed to do. It's his tour. And that's not unusual. Artists often want to bring their personal entourage with them on tours. But the artists are responsible for choosing those people, and they're responsible for what those people do. And this was no different. Let's look at paragraph 15.2 of the tour agreement. That's on page 11 of Exhibit 66. The tour agreement says that Mr. Jackson is responsible for the people he selects and brings. Artist Co. and artist, so that's Mr. Jackson and his company, shall defend, indemnify, and hold promoter, it's AEG Live, harmless for any third-party claims arising out of or relating to the negligence or wrongful acts or admissions of the tour party. He takes responsibility. He had to. They're his choices. He can bring who he wants, but if the people he brings act negligently, the buck stops with him. Now, yesterday, plaintiffs tried to argue otherwise. They tried to say the draft agreements, that provides that AEG Live was going to be controlling Dr. Murray's actions in some way. But this is one of those places where plaintiffs didn't tell you the whole story. Kathy Jory, on cross, told you it was never the intent of anyone at AEG Live to control Dr. Murray's treatment of Mr. Jackson. And you can see that from the evidence in this case. Because during negotiations, Dr. Murray called Ms. Jury and asked her to change the contract. To make it crystal clear, he reported only to Mr. Jackson, not AEG Live. Remember that testimony? He said it. He got a draft and said, no, you got to change this. I don't answer to you. I answer to my client. I answer to my patient. I answer to Michael Jackson, the one who's hiring me. And she made the change immediately, and you saw it. She changed the language because Dr. Murray and AEG Live both understood that Dr. Murray was working for Michael Jackson, not AEG Live. And remember, under the agreement that Ms. Jury was drafting, it was Mr. Jackson, not AEG Live, who had the right to fire Dr. Murray. AEG counsel could cancel the agreement, but only under certain conditions. If you look at it, there are conditions in which they can say, okay, we don't have to advance this money anymore. Like Dr. Murray having insurance or the tour not going forward. If those weren't met, then yeah, they didn't have to advance that money anymore. But Mr. Jackson's the only one, look at it, who could fire Dr. Murray at any time for any reason. Because that's what you do with a patient-client, patient-doctor relationship. That's what you do. You have the right to fire them at any time if you want. Now, the evidence is overwhelming that the only person who ever hired Dr. Murray is Michael Jackson. So that is the first reason, I believe, that you have to answer no, okay, in question 1 on the verdict form. I think all that evidence. It's no, and I think it's clear who hired him, Put down no, it's over. But as I told you, there's a second reason. There's a second reason to put no there. And that's because AEG Live never had an agreement with Dr. Murray. An agreement to hire him or for anything else. The only thing AEG Live was ever going to do with regard to Dr. Murray was to advance his salary on Mr. Jackson's behalf, with Mr. Jackson ultimately paying for it. But even that never happened. As Mr. Panish said yesterday, plaintiffs are claiming AEG Live hired Dr. Murray through a written contract or an oral contract or a contract implied by the parties. Plaintiffs haven't proved any of those things. That's because they can't. They can't prove that any such contract ever existed. And it's their burden. Remember that. It's their burden to prove that. If there's no contract, there certainly was no hiring. Now let's look at the instruction the judge gave you on what is required for a contract, whatever type. In deciding whether there's a contract, you have to show yourself under the you have to ask yourself under the circumstances whether a reasonable person would conclude based on the words and conduct of each party that there was a contract. That's what you look at. But going further, and this is important, quote, you may not consider the parties' hidden intentions, end quote. In other words, you're looking at what the parties actually said, what they actually did with each other. Each party has to know. That's not what one party did. Oh, they did that, so therefore there must be a contract between these two? No, no, no. You have to look at each. Okay, nothing hidden works here. And what did AEG Live say and do that Dr. Murray actually knew about? And what did Dr. Murray say and do that AEG Live actually knew about? And the judge told you it is plaintiff's burden to prove to you that Dr. Murray and AEG Live agreed to be bound without a signed written agreement. That's the instruction. All right? Remember that. Plaintiff's burden to prove to you that Dr. Murray and AEG Live agreed to be bound without a written contract. Plaintiffs never proved that because they absolutely cannot. Both AEG Live and Dr. Murray understood there would never be a contract until Mr. Jackson signed as well. That was what they agreed to. That's the end of the story. How do we know that? Well, it was in the draft agreements exchanged between Dr. Murray and AEG Live. It was in every single draft agreement. And it was in every single one for a reason. Let's focus on paragraph 9. And I'm going to do this in the last one, the last draft, the one that Dr. Murray actually signed on the 24th. Again, this is Exhibit 343, in case you want to go back and look at it. And this paragraph is very important. So let's look at it closely. It makes clear that the effect of the agreement is conditioned upon the approval and consent of the artist, Michael Jackson. Unless Mr. Jackson signs off in writing, there is no contract. There is no agreement between them. Dr. Murray has no rights or obligations as to AEG Live. And AEG Live has no rights or obligations as to Dr. Murray. What does that mean? No one has to do or not do anything. There's no contract. There's no agreement. Dr. Murray can still be Michael Jackson's doctor. He had been Michael Jackson's doctor. He was Michael Jackson's doctor. He could continue to be Michael Jackson's doctor. This has no impact on that. But AEG Live wouldn't be involved in any way, any shape, any form, unless Mr. Jackson signed. Without that signature, there's simply no agreement with AEG Live. Not a written contract, not an oral contract, and not a contract implied by the conduct of the parties. No kind of contract. It doesn't get really a lot clearer than this. Paragraph 9, signature in the bottom, I think it tells you what you need to know. And you've heard how special paragraph 9 is. It was only in Dr. Murray's draft agreement. It wasn't in any other independent contractor agreement on the tour. They told you that. Not in Kenny Ortega's, not in Karen Fay's, and that was because this agreement was going to be unique. When people say, no, I've never seen one like this, I've never seen an agreement like this, that's right. This was different, and that was intended to be different because Mr. Jackson had decided to bring along his longtime doctor. He wanted to bring him on tour. but he wanted AEG Live to front the money to him. That's the reason AEG Live ever even spoke to Dr. Murray. Why would they have ever spoken to him otherwise? Michael Jackson asked them to. But the only way AEG Live would agree to do that, to assume those payments for that deal Mr. Jackson had already had with his longtime doctor, the only way was if Mr. Jackson also signed on that arrangement in writing. Paragraph 9 addressed the idea that you heard Dr. Green, the expert, testify about. He said it's a fundamental right for a person to choose their own doctor. And that all stems from the personal and private nature of the doctor-patient relationship. Now you recall Mr. Trell, here every day, who testified about the importance of this condition in paragraph 9. He testified that paragraph 9 was added, quote, because of the personal request here from Michael Jackson for his particular engagement of his personal physician, end quote. Paragraph 9 was so unique, Mr. Trell testified, that it was not in any other independent contractor agreement he's ever seen in his years at AEG Live. When people say they haven't seen something like that, it's about this. Paragraph 9 was a roadblock. It made sure that no contract of any sort was ever completed without Michael Jackson's agreement and signature. And why is that so important? Because it was Michael Jackson's contract, and he had to agree to it. He was the one who hired Dr. Murray. He was the one bringing his own personal physician on tour with him. Even though AEG Live would be advancing the monies, and they would have, it was Mr. Jackson who would be paying him. Mr. Jackson had to be on board with every term of the contract, or there was no contract. It's easy to say, we knew that Mr. Jackson wanted the contract, that he was the one who demanded Dr. Murray, and he was the one who authorized the payment of the $150,000. But contracts are more complicated than just that. There were many more details involved, and Mr. Jackson had to approve all of them. Mr. Jackson could have decided he wasn't going to take Dr. Murray on tour. We still had a couple weeks. We don't know what he was going to decide. As you saw, there were many times when Mr. Jackson suddenly decided he didn't want to work with anybody any longer. He could have decided to not agree with any part of the agreement. He could have asked for additional changes or corrections to it. His people may have been unhappy with some of the wording of it. And I want to talk about that for a second. Mr. Panish makes a big deal about the fact that Mr. Jackson's people had not yet reviewed the draft contract. But obviously, they would have had to have reviewed it. You heard Ms. Jory's testimony that they wanted to get it as close to done as possible before presenting it to Mr. Jackson and his management. And you saw the declaration of Mr. Jackson's manager. You saw it. His declaration. Not somebody talking about what he said. His declaration. That was his manager, Mr. DeLeo, and he said that he knew all about the draft Dr. Murray agreements. So you can't say they didn't know. They knew. Yes, they hadn't reviewed the draft yet because they were getting it in shape enough so they could now comment. What did Dr. Murray want in this? What did AEG Live expect to do? You get it there, and then they get to look at it. Mr. Panish said yesterday nobody could prove Mr. DeLeo knew about Dr. Murray because Mr. DeLeo was dead. Yes, he is. He didn't testify. And yes, it's true some people talked about what he said. But the evidence of this is in his sworn declaration, not someone else's. It wasn't a secret, and it was going to be sent to Mr. Jackson and his people because he had to sign it before there was an agreement. Now, Mr. Jackson's signing was required because that was the only way that everyone could be sure that Mr. Jackson was agreeing to this. That's why there couldn't be an agreement without Mr. Jackson signing it. Not because AEG Live was in control of Dr. Murray. If they're in control of Dr. Murray, why would they need Mr. Jackson's signature? It's because Mr. Jackson was. Now, plaintiffs want to drive right around this roadblock. And they want to pretend it doesn't matter. Did you hear about it yesterday? That's why they tell you there were 3 different kinds of contracts that could have been made, maybe June 6th, maybe May 6th, maybe June 16th, maybe June 24th, whenever. They're sending all those cars, all those arguments at that roadblock, and they're hoping one of them gets through. Okay, when are you going to say, oh, maybe that works? But paragraph 9 was in every draft that was sent before AEG Live and between AEG Live and Dr. Murray. All three of them. Dr. Murray made a lot of important changes to the first two drafts, but he never changed paragraph 9. He made all kinds of other changes. You saw that. Kathy Drury testified about it, but he never changed this. He never said this has to be taken out. And he didn't change it because he agreed with it. He knew there was no contract without Mr. Jackson's signature. He knew who'd hired him. He wasn't going on tour unless Mr. Jackson decided to take him. Okay, ready? Here's the scenario. Mr. Jackson decides he doesn't want him. So we're going to take him? Of course not. He wasn't going on tour unless Mr. Jackson decided that. In fact, on June 24th, 2009, he signed that agreement. By signing it, he's showing he agreed with paragraph 9. That is an action that he took that shows you that there's not going to be a contract unless and until Michael Jackson signs. He agreed with that. And again, look at it. It's Exhibit 343. Now, this means there's no contract, no written contract, no oral contract, and no contract implied by the conduct of the parties. That was the conduct of the parties. Plaintiff keeps trying to get around that roadblock. So they try to claim there was an oral contract instead. That doesn't fly either. Remember, it's plaintiff's burden to prove the parties agreed to be bound without a written agreement. That's their burden. If Dr. Murray had an oral agreement with AEG Live, he never would have signed a document saying he had no contract without Mr. Jackson's signature. He would have said, no, that's not right. We already have a contract. But he didn't do that because he knew there was no contract unless Michael Jackson signed.
Break.
Oh, I'm going to get in trouble. All right. You heard Mr. Panish argue, thank you, Your Honor. You heard Mr. Panish argue that a contract was created on May 6, 2009. That's the date they gave you, May 6. He says it was created simply because Paul Gongaware called Dr. Murray at Michael Jackson's direction and said that Mr. Jackson was willing to offer $150,000 per month. You remember, done at $150K per MJ? They based that to say that's why there was a contract as of May 6th. But the evidence shows a contract wasn't created that day because the only term that was agreed to that day was Dr. Murray's salary. Lots of other important terms, like how long Dr. Murray would work for or who would be responsible for things like airfare and insurance. They weren't even discussed on that call. That's why Mr. Gongaware contacted Tim Woolley. Remember that? Right after that call, he contacted Tim Woolley, the tour finance manager, and Mr. Gongaware asked him to call Dr. Murray. Why? Because there wasn't a contract yet. Both sides needed more information. And more important, they needed Mr. Jackson's written approval. Mr. Woolley knew that too. You heard his testimony that he didn't think there was ever a contract with Dr. Murray.
Sir, do you recall having an agreement with Dr. Murray that you were going to pay him for May?
I didn't have any agreement with Dr. Murray.
Did AEG have an agreement with Dr. Murray?
Never.
That they were going to pay him for May? Never.
No, I don't remember that there was ever a completed agreement between AEG and Dr. Murray.
I'm not asking those questions. They are. What about Mr. Woolley's back and forth emails? The ones with Dr. Murray? Did they create a contract? Again, the evidence shows the opposite. Just look at Mr. Woolley's first email to Dr. Murray. This is Exhibit 177, and I'll finish right after this one, Your Honor. This email is a summary of Mr. Woolley's first and only call with Dr. Murray. His first and only call. Let's look at the last sentence. Mr. Woolley says there, quote, lots to consider, end quote. He's, quote, happy to continue the discussion, end quote. If there was a contract, there wouldn't be lots to consider, nor would you need further discussion. And the subsequent emails that we'll talk about after the break makes that really clear. And if there was a contract on May 6th, he wouldn't be saying this to him on May 8th.
Okay, thank you. Let's take a break, 15 minutes. Let's come back at 11:30.
Thank you.